reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have. Good morning, you're Lamone Yeoman Jr. And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts.
Right from the start, this case is already serious. The defendant isn't here for a first mistake. He's here because probation conditions were allegedly violated after convictions involving a deadly weapon and burglary. When someone is on probation, the court expects strict compliance. Missing even basic requirements like reporting can quickly turn into a full probation revocation. Exactly what we may be seeing unfold here.
1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are we ready to go forward?
No, Your Honor.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the. I believe you pled true, not true to number 7, which is failing. I do want to address those.
Okay.
So I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence presented on that yet.
Okay. Hold that. You may proceed.
Would you please?
I'm sorry. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And how long have you worked with probation? And during your time with probation, you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th. You've not seen him since.
Until he was arrested.
So, is it safe to say that on April 11th, 2025, April 21st, 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required?
Notice how detailed the reporting dates are: April, May, June, and July. That's not accidental. In probation cases, prosecutors build a timeline to prove a pattern of noncompliance, not just one mistake. The more consistent the missed reports, the stronger the case becomes. Do you think missing appointments should automatically mean prison, or should courts allow second chances?
To see you or permission.
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report?
April 7th.
And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him about one. He told me because it was his birthday.
Are you aware of any times while he's since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get filled in?
I called, I sent letters, and I called his mother. And his mother told me that he was aware of it.
I pass the witness.
Another question for purposes of proving that count number 7 or not.
Okay. Based any witnesses or information about count number 7?
Okay.
All right, then based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so again, I've got the updated pre-sentence report, as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter? It's from. And take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of it.
Okay. I guess being kicked out is better than being absconded. Anyway, all right. Anything else?
This is the PSI number.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in safe P. He did successfully finish the first part of safe P. The aftercare program is a part that he was kicked out of. He pled not to count one as far as, I believe that counts since he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall for him on probation. Because at that point, he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the message was given to him to report, he wasn't able to. He didn't know about those. When he finally
Here we hear the defense explanation. Transportation problems, lost phone contact, and confusion after being removed from a program. These kind of explanations are common in probation hearings. But courts usually ask one key question. Did the defendant make a real effort to stay in contact? Because legally, the responsibility to report always stays with the person on probation.
get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August as far as the possession and the weapon charge. So according to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much. There's not much for you to argue here today.
I
is there?
don't
You
wanna
haven't
say
given
that
your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that safety program, and that's what he's asking to get the opportunity to do this morning. Is finish that aftercare program, possibly even due to those new offenses, Michael G. Weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at safety, Mr. Young is willing to talk about this.
So there was an ISF. Okay, there have been 7 administrative hearings. 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally at what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case. While you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second, and then...
This is a turning point. The judge lists multiple chances, prior violations, and new crimes while on probation. In courtroom reality, judges often become less forgiving after repeated violations. Probation is meant to be a second chance. But once that trust is broken several times, prison becomes far more likely.
And we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances And if you go back to his original PSI from 2019, from the 2019 offense, the Agassiz, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct, and that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's going to keep giving me probation. I'm going to come in, I'm going to write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find...
Listen carefully to the judge's tone here. Frustration is obvious. When a judge has a defendant made them look like an idiot, it usually means patience has run out. At this stage, sentencing is rarely a surprise. The 8-year sentence reflects not just the original crime, but the repeated failure to follow court orders.
In cause number 19-32846, that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the paper. Thank you. Thank you. Good morning. Are you Adrian Hayward Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hayward, in cause number 24, DCCR 2149, you're charged with the third-degree felony offense of assault family violence by impeding breath or circulation from May 23rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what
This
is
is his first case I'm showing, Your Honor. If he's going to be released on bond for sentencing, I'd ask, obviously, that no contact with the victim, he stay away from that address, but he not be allowed to possess a firearm. While the allegation isn't for using a firearm, there's allegation in the reports that he had brandished ones at him.
What's your relationship with Rihanna McClain? It was your what? Your ex-girlfriend's cousin. So there's no reason for you to be around her, or it sounds like your ex-girlfriend at all, or anybody like that, right? So here's what I'm going to do. Based on the nature of your plea agreement, I'm going to reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have absolutely no contact or no communication in any way. That's obviously in person, but it's through social media or sending messages or anything with her. Do you understand? You can't go to an address where she is. If you're somewhere and she shows up, you have to leave. Do you understand? And then also, as a condition of your bond, you are not allowed to have any firearms at all. So if you own firearms, you need to get rid of them. If you have a family member that can take them, I don't care what you do with them, you can't have them or have them in your home or your car, okay? Any questions? All right, we'll see you back at sentencing.
The contrast between these two defendants is striking. One man loses probation and goes to prison for repeated violations, while the next defendant receives deferred probation and another opportunity. It shows how much outcomes depend on criminal history and behavior on supervision. Which outcome do you think was fair? The prison sentence or the second chance?